ಕಾಗ್ನಿಸೆನ್ಸ್ ಇದ್ದರೆ ಅನುಮತಿಯನ್ನ ನೀಡಬಹುದು. ಅಂದ್ರೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ಗೆ ಅನುಮತಿಯನ್ನ
ವಾದ ಮಂಡಿಸ್ತಾ ಇದ್ದಾರೆ. ಎಎಸ್ಪಿ ಮಣಿಂದರ್ ಸಿಂಗ್ ವಾದ ಮಂಡಿಸ್ತಾ ಇದ್ದಾರೆ. ಮೂಡದಲ್ಲಾಗಿರುವಂತಹ ಪ್ರಕ್ರಿಯೆಗಳ ಬಗ್ಗೆ ಅವರೀಗ ವಿವರಣೆಯನ್ನು ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಸೊ ಇಡೀ ಕೇಸ್ನಲ್ಲಿ ಒಟ್ಟು 4 ಮಂದಿ, 4ನೇ ಪ್ರತಿವಾದಿ ಸ್ನೇಹಮಯಿ ಕೃಷ್ಣ, ದೂರು ಕೊಟ್ಟವರು, ಸಿಎಂ ವಿರುದ್ಧ ದೂರು ಕೊಟ್ಟಂತ ಸ್ನೇಹಮಯಿ ಕೃಷ್ಣ, ಅವರ ಪರವಾದಂತ ವಕೀಲರು ಸದ್ಯವಾದ ಮಂಡಿಸ್ತಾ ಇದ್ದಾರೆ. ಸ್ನೇಹಮಯಿ ಕೃಷ್ಣ ಅನೇಕ ವಿಚಾರಗಳನ್ನ ಪ್ರಸ್ತಾಪ ಮಾಡಿದ್ದಾರೆ. ಅವರು ಒಂದು PCR ಕೂಡ ಖಾಸಗಿ ದೂರನ್ನ ಕೂಡ ಜನಪ್ರತಿನಿಧಿಗಳ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಲ್ಲಿಸಿದ್ರು. ಸೊ ಅದರದ್ದು ಪೆಂಡಿಂಗ್ ಇದೆ. ಈ ಕೇಸ್ನ ಕಾರಣಕ್ಕಾಗಿ ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ. ಇಲ್ಲ
ಮಂಡೇ ಆಗಲ್ಲ, ಕೊಡಿ ಮೆಮೊ ಕೊಡಿ. ಮಂಡೇ ನಾಟ್ ಪಾಸಿಬಲ್. ಮಂಡೇ ಆಲ್ರೆಡಿ 300 are listed. I am not possible.
My lord, serial number
charge sheet ಆಗಿದೆಯಾ? I will not put the clock back now. Yes.
Serial number 104, my lord.
You want to withdraw?
I'm going to withdraw the petition.
ತಗೊಂಬಿಡಿ.
So please.
Hey, whatever has happened, fresh matter kudi. Yes.
sir.
Give it. Iskoli. All right. 6ನೇ ತಾರೀಕು, 4ನೇ ತಾರೀಕಿಗೆ ತಗೊಳ್ಳಿ. ಅದು GMಗೆ ಹೋಗ್ಬೇಕು, ಪಕ್ಕದ ಕೋರ್ಟ್. ರೌಡಿ ಶೀಟ್ ಅಂದ್ರೆ GM. You should go to the next court, sir. FIR ಆಗಿದೆ ಕೊಡಿ. Yes. Fresh matter. Pending. Give it. Yes. We'll see. Give it. Yes. Give it. Yes. We'll see. Which year? 20? All right. Give it. We'll see. We'll fix it next week. But other next week happen. Other next week happen. Week commencing after the 9th. Yes. All right. I guess the learned Solicitor General is for this case. Yes, sir.
Yes, subject to your lordship's convenience.
Yeah, no, we'll start. Yes. With this in the first list.
Yes,
we'll start this.
Yes. I'm grateful, my lord. I'm appearing in person before your lordship for the first time. It's really a privilege, my lord. I was looking forward to this. Lord, I'll be very brief because your lordships are aware of.
Yes, sir.
Broad conspectus of the facts.
Yes.
But from the petitioner's perspective, your lordships have also dealt with, my lord, the issues as, my lord, judgments, my lord, which I am going to refer.
Yes.
So I'll not read. I'll just see the propositions which your lordships have already read.
Yes.
Lord, my submissions are going to be, my lord, in 5 compartments. First, the
settle down, sir. Yes.
yes, yeah, please.
Yes, sir.
From the order, which is page 40 vacant.
Which the impugned order?
Yeah.
I don't know, sir. You are appealing for petitioner. Oh.
Page 41 starts. Kindly come to page 42.
Yes.
It reads like this. Petition from Sri T.J. Abraham seeking grant of sanction for prosecution Sri Siddaramaiah, Honorable Chief Minister of Karnataka, for commission of offences under section 7 so and so of the Prevention of Corruption Act. Kindly mark the next phrase. Sections 59, 61, 62, etc., of Bharatiya Nyaya Samhita. The said petition seeks sanction, etc. Now, after this, there is no reference to any provision of either the Indian Penal Code or the BNS Act. And sanction is given to prosecute under these provisions. Now, as this Honorable Court is very much aware, these provisions came into force on 1st of July. The last of the alleged acts against the petitioner's family, not against the petitioner's family, ended on 5/1/2022 when the allotment of sites was made. Admittedly, on that date
BNS was not there.
was not there. How can there be a prosecution of under a law which are mainly permitted
No, you're
to show?
talking of post facto law.
Article 20 may kindly.
Yes, yes.
I agree, it cannot, it has to be prospect. I have an answer to that. Though
So,
Dr.
Post
Singhvi didn't
facto law,
argue,
that is,
Yes,
That
so
is-
Article 20 it died.
that's all.
Now, this has two limbs. Number one, it is hit by Article 20.
All right.
Number two, His Excellency, the governor does not even whisper about this aspect of the matter. He could have applied his mind and said, this is relatable to provisions under the IPC Act. These are the provisions, etc. He could have said it, all right, notwithstanding the prayer. But that is not the case here. Since there is no mention of any one of these provisions in the entire body of the order of the governor. So on that count alone, this order has to go, is my very respectful. And
Here, here the others.
second aspect is that ultimately all the allegations are against Parvati and her brother. Not a single allegation against the petitioner. As having passed an order, having taken a decision,
That's
made a recommendation.
elaborately submitted.
That is,
Yes.
no, the point I'm submitting is there vicarious liability of a husband for the deeds of either the brother-in-law or the wife? That's a short question.
No, that stage of drawing in vicarious liability on investigation or on something else has
government
not
should
yet
be
arrived.
satisfied
We'll
that
Not the
husband
way-
is liable for all the acts of his wife
see.
or her brother.
We'll
If
see.
he is satisfied, yes, sanction can be given.
not the scheme of the architecture of. the
Pious obligation is well understood. But there is no
Obligations,
such,
highest obligations are well understood.
Pious
Not a-
obligations, yes. Yes, sir.
but husband's obligation for the crimes of a lady.
That will, we'll hear this also.
So one of the pious obligation on the lighter side
Yes,
is not to shift a criminal liability on the wife.
to take on himself.
Yeah, yes, that is one of the pious, that is on the lighter side.
Yes, sir, yes. Sir.
Yes. My lord, my submissions are, my lord, in six compartments.
Yes, sir.
My lord, first, my lord, the arguments are advanced about the scope of the governor's power under section 17A,
Yes.
relying upon the parameters prescribed under section 19.
Yes, sir.
My lord, I would wish to assist your lordships on the question that section 17A stage
Yes. sir.
and application of mine. I'll take your lordships through, my lord. I'm just giving
Yes.
outline of what I'm respectfully assisting your lordship with.
Yes.
What are the differences between the provisions of 17A and 19, and resultantly, what will be the parameters of governor's jurisdiction, governor's power, or governor's duty, whatever we may call it, while exercising powers under 17A or 19. Second, my respectful submission is that the parameters of the governor's jurisdiction under 17A would be akin to what is described by the Honorable Supreme Court in Lalita Kumari's case, that he has to see a prima facie case whether the facts emerges a cognizable offense or not. If the facts reflects commission of a cognizable offense, he is not a judge. He is not supposed to sit in appeal and decide whether offense is committed, not committed. He has to say that yes, as alleged, there is a cognizable offense, and he has to discharge his function under 17A. Third, the decision of the governor, because of two reasons, by the virtue of the office he holds, and he deals with other constitutional functionaries generally, and considering the very nature and scope of section 17A, is such that his reasons, which are recorded in the order of approving 17A investigation, need not be elaborate. It must reflect application of mind nonetheless, because any elaborate reasonings will have a tendency of prejudicing the potential accused during the investigation as well as during the trial. But I must show, it's the duty of my lord the governor to show that there is an application of mind, and thereafter the reasons are recorded and the reasons can be found from the file also. The next submission, my lord, which I am making, my lord, my learned friend's argument was that in case of one complainant, the governor issued notice. In two cases, the Honorable Governor did not issue notice. My lord, my respectful submission in law, and which I will substantiate by, my lord, the provisions as well as the legal interpretations given by the courts,
Yes.
that at the stage of 17A, there is no requirement of any principles of natural justice.
Yes.
He may have chosen to issue notice in one case, but non-issuance of notice, even in that one case, would not have created any prejudice to anyone, because in law, there is no contemplation of hearing. And I will elaborate, my lord.
At the stage of 17.
At the stage of 17A. Because Supreme Court has went to the extent of saying, even at the stage of 19, hearing is not required.
Yes.
Yes, because 19 is post-investigation.
Yes.
Lord, next contention I would, my lord, assist your lordship with is why the governor was required to act in his own discretion and not, my lord, as per the aid and advice as, my lord, contended by the petitioner. Aid and advice of the Council of Ministers under Article 163 of the Constitution will have no application when the Honorable Chief Minister is facing an allegation. I'm saying only allegation.
Yes.
It is yet to be decided. And the governor is called upon to decide 17A. My lord, the submission, my lord, which my learned senior, my lord, just now made.
Yes.
Professor Ravi Kumar Verma, my lord, a very eminent counsel, my lord. I have had an occasion to oppose him in one of the reservation matters before the Constitution bench. My lord, the submission is that mention of BNS vitiates the decision of the governor. My lord, that submission is required to be, my lord, only pointed out to be rejected for the simple reason that suppose IPC offenses are also mentioned. The governor will not go under 17A which offenses are made out. Governor will only say that yes, prima facie, criminal offenses are made out, and it will be for the investigating officer to decide under what provisions charge sheet, if any, is to be filed. Because the investigation may result into filing of the charge sheet, it might result into filing of a closure report, but in the event of filing of a charge sheet, the investigating officer will take his own independent decision based on the material of the record that these are the provisions which are attracted, which, Lord, in a given case of
earlier also procedure, it is not yet referred even for investigation. So while referring, these crimes may be noted, may not be noted.
correct, my lord.
That's all.
And even if it is noted, IO will not be bound by them. Maybe the governor has missed 2-3 sections, hypothetically. The IO can still say that the Honorable Governor did not have full facts. The Honorable Governor was relying upon only a written complaint. Now I have investigated, I have documentary evidence, I have oral evidence, I have other evidence, and now I feel that 3 other sections are also required to be added. Then he would add it. So mention of BNS, IPC, or any of the sections or non-mention thereof would not vitiate the order, in any case will not cause any prejudice to the petitioner so as to give him an opportunity to challenge it on that ground. And last, my lord, which again, my lord, my learned senior friend, my lord, mentioned that the criminal liability of the husband, of the wife, cannot be attributed to the husband. Dr. Singhvi also made a submission that I have not made any recommendation. If that is so, then fine, then 17A is not required. the complainant can straight away proceed with the criminal complaints. Then 17A goes, my lord, their problem is solved. They should withdraw the petition that I have not done anything in my official capacity. I have not recommended anything. I am not involved. Maybe my wife was beneficiary. All right, then 17A is not required. Then what are we arguing for? Why are we troubling your lordship with? By showing justification for validity of 17A order. Lord, it's a self-defeating, suicidal argument, in my respectful submission. Now, my lords, my lord, I have prepared a summary of my submissions, my lord.
Yes, sir.
And so far as governor's application of mind is concerned, my lord, I have gone through the file. I will share the file with your lordships.
Yes.
And without making it a precedent,
Yes.
I will share with the other side also.
Yes.
Though, my lord, in law, my submission
Okay.
is that the potential accused cannot have an access to
Yes.
that file, but we don't wish, my lord, anything to play hide and seek. My lord, I'll show it to the petitioner also that this is the application of mine, and based upon the considerations which are reflected from the file, the governor has reached the conclusion that this is a case for 17A and he has passed the order. My lord, these are my written submissions. I'll give it.
Yes, sir.
Lord, page 5, your lordship may directly come to page 5. Up to 4, my lord, I have only pointed out. This is the skeleton on which, my lord, I'll address your lordships.
Yes.
Lord, 26th of July 24, a show cause notice dated 26th July 24, which is placed by, my lord, the petitioner at annexure C, was issued to the petitioner in relation to the petition seeking grant of approval for investigation on the basis of complaint filed by respondent number 3. My lord, it is an admitted position that what is the content of the show cause notice is only the complaint of respondent number 3 and not the other 2 complaints. Because my submission is going to be even this step was not necessary. Therefore, non-compliance with other 2 makes no difference, creates no prejudice, gives no cause of action. Then, my lord, on 31st of July 24, a cabinet note was put up for consideration of the Council of Ministers in relation to the show cause notice issued by the Honorable Governor of Karnataka to the Honorable Chief Minister to respond within 7 days as to why sanction for prosecution should not be granted, as requested by one Sri T.J. Abraham in his application dated 26 July 24. The cabinet note in its introductory paragraph notes as under. Lord, please read. The Chief Minister, with his note dated 27th July 24, the next day of, my lord, receipt of notice, has directed the Chief Secretary to place the matter of a show cause notice issued by the Honorable Governor of Karnataka, addressed to the Chief Minister of Karnataka, video number so-and-so, before the cabinet, along with all the materials available on record with the Urban Development Department and after consulting with the Learned Advocate General. Accordingly, the Chief Secretary, after obtaining the Advocate General, it should be the opinion of the Advocate General, but the mistake is in the original note, my lord, it's not in
Yes,
this.
yes.
Accordingly, Chief Secretary, after obtaining the opinion of the Learned Advocate General and examining the records, directed the Urban Development Department to put up a cabinet note with details along with the opinion of the Advocate General on the matter for consideration of the cabinet. My lord, here, on a lighter note, my lord, nowhere the government writes Learned Advocate General. My lord, that is the practice throughout. I'm not criticizing. I'm saying on a lighter note because, Lord, there was, my lord, an eminent lawyer called F.E. Smith. Yes. He had said 3 things. That in the court of law, never believe 3 things. When the honorable judge says, my learned brother, he neither means that he is learned, nor he treats him as a brother. Second, when I say, my learned friend, we are generally friends, but we rarely treat each other as learned. And, my lord, and when we say that with profound respect, Lord, with profound respect generally mean as per him, my lord, this is not my interpretation, that your lordships have not understood, but let me make your lordship understand. And my lord, he has elaborately detailed that my lord, with respect means you have not understood. Lord, with profound respect means you have completely not understood.
Not at all understood.
Not at all understood. So these are the jargons. So we call each other learned. And that is the irony, my lord. When your lordship set aside the order of the trial court, your lordship would say the learned judge has not understood even basic fundamentals of law. My lord, if the second part is true, then how is he a learned judge? But this is, my lord, what we live with, my lord, since centuries. Then the cabinet note dated 31st of July at annexure D from page 267 of the writ petition filed by the petitioner. Then Council of Minister through its cabinet decision advised the Honorable Governor to withdraw the notice dated so-and-so issued by him to the Honorable Chief Minister based on the petition and addendum dated so-and-so filed by one T.J. Abraham and to proceed forthwith to reject the said application by denying prior approval and sanction as requested by the petitioner Abraham. The decision of the cabinet is, my lord, also placed by them.
Yes.
The petitioner submitted his reply to the show cause notice dated 26 July 24, which is also annexed, and something very interesting from the note prepared by the Chief Secretary. Thereafter, the learned Advocate General. Thereafter, the matter comes to the cabinet. Thereafter, the Honorable Chief Minister prepares his reply, etc., which I'll come, my lord, when I deal with that. Respondent number 2 placed the file in relation to the issue at hand, along with the decision of the cabinet dated so-and-so and reply of the petitioner dated so-and-so before the Honorable Governor. The respondent number 2 is the Secretary to the Honorable Governor, Lord, whom I represent, and he placed that these are the papers. This is the note of cabinet. The cabinet has to say this, and all documents, as I will show from the file, complaints, documentary evidence is annexed with the complaint, etc., my lord. The opinion of the learned Advocate General, everything was placed. Then, 8/8/24, the Honorable Governor directed respondent number 2 to put up the file along with comparative statements of the petitioners. Petition, my lord, he understands, my lord, to be complaints.
Oh, this was done.
Yes, my lord. Well, there is an elaborate application of mine. I'll show from the file. I'll share it with my learned friend. The Honorable Governor directed respondent number 2, that is his principal secretary, to put up the file along with comparative statements of the petitions received in relation to the grant of sanction, reply of the Chief Minister, and the decision of the cabinet. That you give me in this format, then I'll make up my mind. Then 14th August, comparative statements as referred above were placed before the Honorable Governor for his perusal. 14th August 24, after perusing the file and discussing the issues, the Honorable Governor directed to resubmit the file along with notes or analysis points as dictated. The learned Governor dictates that this is the allegation of the complainant. This is what the cabinet note says. This is what the reply of the Honorable Chief Minister says. And this is the note. The note is dictated by him. I'll place it. It's a big chart, my lord. Several charts were prepared. And the Honorable Governor, my lord, himself dictates. Based on, and this comes, my lord, in the noting file also. It's not that I'm saying for the first time that it was dictated by the Governor. In the noting file, my lord, it comes that it was dictated by the Governor. Based on the comparative statement and available documents and petitions. The file, along with all the above referred documents and comparative statements as dictated by the Honorable Governor, was placed before the Honorable Governor for necessary orders. The order of approval for investigation was passed by the Honorable Governor, and my lord, thereafter, my lord, the petitioner is before your lordships. Now, my lord, taking the first point first. Lord, your lordships are aware, prior to, my lord, the enactment of the new Prevention of Corruption Act.
Yes.
The amendment to the Prevention of Corruption Act, my lord, which was in
26/7/2018.
Yes, my lord, 18. There was no concept of an approval prior to the investigation. The only concept was pre-cognizance sanction under section 19. My lord, for the first time, 17A comes, my lord, your lordships have read and reread this provision, but only read kindly, my lord, on my request,
Yes.
page 8, page 8, only subsection 1.
Yes, sir.
No police officer shall conduct any inquiry or investigation into any offense alleged to have been committed by a public servant under this act. It doesn't talk of BNS or IPC. Under this act, where the alleged offense is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions or duties without the previous sanction of ABCD. My lord, according to me, this case would fall within B and C, but I'll have to independently substantiate that it is the governor in case of the Honorable Chief Minister who is not supposed to act as per the aid and advice of the Council of Ministers. Now, my lord, so far as this is concerned, my lord, I have already pointed out that the scope is very, very limited. I have to, as a governor, see whether the complaint and the documents which are placed makes out a cognizable offense which requires investigation. It may result in a charge sheet or the report under 173 as we call it, or a closure report as per old section 169. But that's not the call the governor is permitted also to take. The governor cannot say that I have examined and cognizable offense is made out. It's of a serious nature. It will be attracting this provision. It will be attracting so much punishment, etc., etc. No, he will go by prima facie case that whether it needs to be examined by an investigating agency as an investigation under the provisions of law. Lord, your lordships have had an occasion to consider, my lord, this honorable court had considered, your lordships, my lord, thereafter, my lord, gave a detailed and illuminating decision. But Sri Rupa,
Yes.
my lord, I would your lordships like me to, my lord, place for your lordship's
Yes.
consideration?
Two very different concepts.
Yeah, yes, my lord.
Approval and sanction, they stand on different.
They stand on different footing. The parameters are different, the considerations are different, the way in which you deal with the application is also different.
In that case, there was nothing said.
Yes.
Nothing said except saying we grant approval.
Approval.
There was no application of mind at all in that case.
Yes.
That's why that was.
And my lord, they are relying upon these judgments to show that there has to be an application of mind. My lord, in my respectful submission, to canvass a proposition that any administrative order has to be after application of mind, you don't need any judgment.
It's rudimentary.
It's elementary, my lord. It has to be after application of mind. You don't need any judgment. There are certain, my lord, universal propositions which doesn't need to be supported by any judgment. I'm straightway conceding. It has to be after application of mind. It will depend upon facts of each case. And what is the extent of application of mind
That
is
Case to
relevant.
case basis.
Is based on facts to facts.
Facts.
So, my lord, I'm placing it, my lord, but I'm not reading, my lord, this judgment. Lord, kindly see what would be the scope of the power, my lord, because your lordships would be laying down the law in while deciding this, not only with reference to a scenario where the honorable governor, who is a constitutional functionary, is deciding the approval issue of the honorable chief minister, who is also a constitutional functionary. 17A applies across board.
Yes.
In case of a tehsildar or a patwari, maybe the tehsildar is or deputy collector is this authority under 17A.
17A.
So, what is the scope of his inquiry? What is the scope of his application of mind? Whether to exercise 17A power as requested by the complainant or not to exercise. Lord, that broadly, in my respectful submission, we can get assistance, my lord, from Lalita Kumari judges.
Yes.
That your lordship would find at page 12. My lord, I can take your tell your lordship, my lord, whatever paragraphs I have quoted,
It's quoted.
I have, my lord, the full text of the judgment,
Yes.
which I'll place.
Yes.
But this is only for ready reference.
Yes.
I'll place, my lord, the entire bunch, my lord, for your lordship's consideration.
Yes.
Right now, my lord, I'm not giving.
Yes.
My lord, please come, my lord. This is a your lordships are aware it's a constitution
Yes.
bench. 5 honorable judges, my lord. 31.
Yes.
And I'll skip some of the paras, my lord. The FIR is a pertinent document in the criminal law procedure of our country, and its main object from the point of view of the informant is to set the criminal law in motion, and from the point of view of the investigating authorities is to obtain information about the alleged criminal activity so as to be able to take suitable steps to trace and to bring to book the guilty. Now kindly come to page 30, para 49. I'll skipping my lord other paragraphs.
Yes, sir.
49, highlighted bold part. Consequently, the condition that is sine qua non for recording an FIR under section 154 of the code is that there must be information, and that information must disclose a cognizable offense. This applies squarely to 17A. If any information disclosing a cognizable offense is led before an officer in charge of the police station, someone has forgotten, my lord.
These things happen.
Yeah, these are, my lord, some interesting incidents in the virtual hearing.
They are the
Must disclose a cognizable offense. If any information disclosing a cognizable offense is led before an officer in charge of the police station satisfying the requirement of section 154(1), the said police officer has no other option except to enter the substance thereof in the prescribed format, that is to say, to register a case on the basis of such information. Lord, I am not comparing the police officer with the governor, but I am saying police officers' function under 154 is the function of any approving authority under section 17A. He may be a tehsildar or he may be the honorable governor. That whether prima facie offense is made out, then not only is duty bound, it is not only his right, he is duty bound to accord approval. The provision of 154 of the code is mandatory, and the officer concerned is duty bound to register the case on the basis of information disclosing a cognizable offense. Thus, the plain words of section 154(1) of the code have to be given their literal meaning. The use of the word shall in 154 of the code clearly shows the legislative intent that it is mandatory to register an FIR if the information given to the police discloses the commission of a cognizable offense. Therefore, the context in which the word shall appears in section 154(1), the object for which it has been used, and the consequences that will follow from the infringement of direction to register FIRs, all these factors clearly show that the word shall used in 154(1) needs to be given its ordinary meaning, etc. My lords. My lord, my learned friend may be tempted to say that in case of 17A, it is not shall. The shall is used only with regard to the police officer and not the governor.
Yes.
I am using this judgment, my lord, for assisting your lordships to say that these are the parameters the governor will bear in mind. That I am not supposed to conduct a trial. I am not supposed to even examine whether I would ultimately give sanction for section 19.
No, it is at stage of 17.
17.
So it's one.
Because section 19, he would be having the material
Yes.
filed by the police, and his parameters would be again different. The threshold would be high.
This is only prima facie.
This is only prima facie. If there is a cognizable offense made out, he has to give approval, whether he is governor or a tehsildar. Yes, ma'am. The only exception, my lord, in Lalita Kumari is that in case of Prevention of Corruption Act or matrimonial offences, conduct a kind of a preliminary inquiry. That is for the police officer. Here, he has to apply his mind. Preliminary inquiry does not mean
6 clauses in para 20.1, 120.1.
120.1.
Yes.
So here, my lord, he is conducting a preliminary inquiry within his mind that it is whether case is made out or not. My lord, why I say this, my lord, what will be the disastrous consequence if we read, my lord, the principles of natural justice into it? As I said, my lord, it's not a case of Honorable Governor and the Honorable Chief Minister. This would apply to all public servants under the Prevention of Corruption Act. In many cases.
So if I can. So the suggestion is, if natural justice is to prevail prior to 17A, and you're paraphrasing 17A to 154, then before registration of FIR, notice will have to be given, heard.
Exactly.
That will
My
have-
learned friend in
it would
fact
be there.
cited, my learned friend in fact
That is what you're
cited
trying to.
Rajesh
Yes.
Agarwal judgment,
Yes. that's right.
where he said that he had an honor to assist the Honorable Court. I incidentally also had an honor to assist the Honorable Court, where my learned friend either inadvertently missed that part where the Honorable Court said that in criminal matters, hearing is not required in that very judgment. Otherwise, my lord, kindly see the
Otherwise,
consequence.
prior to 154(1), every accused will have to be heard. Now, of course, in the new BNS under 218 and this pre-cognizant stage, yes, a notice is required.
No, even there, the Supreme Court says not required.
Yes.
Perhaps my learned friend was on VC, it missed out. I said the argument was that to declare account fraud is like an FIR. So how can you hear before an FIR? The court made the distinction that no hearing is required before FIR. But to declare an account fraud, which is akin to criminal, you must have a hearing. That is the distinction I made.
That's
Perhaps you
correct.
missed it
Yes.
on the VC.
Lord,
Yes,
kindly,
yes.
kindly, my lord, consider if my learned friend is right that before granting approval under 17A, a hearing is required. 17A is for the prevention of corruption offences. It applies over the board
Yes.
to every public servant.
Yes.
The moment, my lord, notice is given, there are all possibilities, my lord, that the evidence will be lost. That is one more reason, my lord, not to read hearing or principles of natural justice under 17A. Suppose, my lord, a collector were to give approval for the deputy collector's corruption case and he is in office, he might, my lord, tamper with the evidence. He might misplace the file. The evidence will go. This is one more reason why 154 or 17A, no hearing.
Except the preliminary inquiry that is in 120.1 of Lalita. Kumari.
Yes, my lord. In a given case, in Lalita Kumari says, my lord, that if it is something, lord, suppose I go and file a FIR which is completely absurd, that Mr. So-and-so I approached and he demanded 50,000 rupees. Then straightway don't register an FIR and pick him up. Conduct a kind of a preliminary inquiry because it's the station house officer who does this.
Yes.
While here in 17A, why that preliminary inquiry is also not contemplated. Only contemplation is whether you find cognizable offense being made out from the material on record. So merely because the Honorable Governor thought it fit to issue notice in one case does not necessarily mean that non-issuance of notice in other two
Will
cases
vitiate the proceeding.
would vitiate the order. Now, my lord, I am relying upon at page 14, my lord's, my lord, very illuminating judgment, my lord, in Dr. Ashok versus the state, where your lordships were pleased to
Yes.
lord, distinguish.
17.
And I think this is the first judgment, my lord,
Yes.
juxtaposing 17A and 19, my lord.
Yes.
And, my lord, your lordships were based upon that judgment, my lord. There is a direction also issued, my lord, by the
High Court.
High Court, my lord,
Yes.
that even it applies to the magistrates. The magistrate also cannot straightway issue process or call upon the complainant to be in the witness box, etc. The complainant will have to go with 17A. So, my lord, I'm not reading, my lord,
Yes,
Dr.
yes.
Ashok, my lord, it is your lordship's judgment,
Yes.
my lord. Now, I will show, my lord, how there is an application of mine.
Huh.
My lord, kindly have, my lord, the original file. I'll share it with my learned friend, Mr. Singhvi and Professor Ravi Kumar also, but I'll have one more copy. You have copies? And the learned advocate general also, my lord, by virtue of his office, though he is not concerned with the
Give-
list between, my lord, the Honorable Governor and Honorable Chief Minister, but I understand his position, my lord. And by virtue of his office, he is entitled to have the access. Huh? He is rightly sitting on our side, my lord. My lord, government is always on the left. Some, my lord, Honorable in High Court, Honorable Judge asked me, in Gujarat also, my lord, the government sits on the left. That
Yes.
why does the government sits on the left? I said, we always sit on the right side of law.
Yes, sir.
I'll share the
This-
original
this is
file.
the
which
entire
are-
file.
This is original. Yes. Lord, I have shared the original file with your lordships.
Yes, sir.
And obviously, my lord, I am getting, giving Xerox to my learned friends. And I can assure your lordships,
I'll hold this with me.
certainly, my lord, your lordships can,
Yes.
only, my lord, ensure that it doesn't go
No.
out.
That's,
And I would request my learned friends also that that can remain only with them and their clients. It may not travel beyond. Nothing is secret, confidential, or anything which needs to be hidden, but there is some sanctity attached to the governor's
Office, to the
office.
office.
And I'm, my lord, at the cost of repetition, maintaining that this is without making it a precedent.
yes.
Just to show that there is nothing to hide, A, and two, there is always, there is an application of mind, according to me, more than what was required. My lord, your lordships are not supposed to go through the entire bulk. Please see, my lord, the first part, which is, my lord, the noting section.
Noting section.
This is the noting section. You have give it to the next page. Yes. My lord, this is the note. Page 1, your lordship would find it is continuously paginated
Yes.
and paragraphed throughout till the decision is taken.
Yes.
My lord, this is the note placed by the, my lord, principal secretary to the governor for consideration of the governor. I will not read it, my lord. It merely reproduces para 1. Kindly peruse the petition submitted by Sri T.J. Abraham, dated so-and-so, placed in the file. Then, my lord, what is the content he mentions? And eventually, my lord, he writes, please peruse papers. He requests the Honorable Governor. The complaint and addendum submitted by Sri T.J. Abraham may be perused in file. He has requested sanction of prosecution against the sitting Chief Minister under various provisions quoted so-and-so. With this fact, the file is submitted for further orders. Now, my lord, the Honorable Governor on page 3 and note number 8 makes this note. I have heard Sri T.J. Abraham in person and gone through the petition and supporting documents submitted by him. Prima facie, I am of the view that there might be irregularities and misuse of power. He doesn't reach a conclusion of criminal offense, but he took care to see that there is genuinely a person. It's not an anonymous kind of or a pseudonymous kind of a complaint.
Because the complainant himself has appeared.
It has appeared. He was heard. He shown the documents, etc. Hence, issue show cause notice to Sri so-and-so, calling explanation within 7 days. Thereafter, my lord, kindly come to page 5. Lord, it further goes on. As per the order of the Honorable Governor, draft copy of the letter, my lord, that is draft copy of the show cause notice, my lord.
Yes.
Then the show cause notice goes.
Yes.
Please come to page 7. Lord, again, the Special Secretary to the Governor writes, kindly peruse the letter dated 3rd August 24 received from Sri so-and-so and letter dated so-and-so received from the Chief Secretary to Government placed in the file. The Chief Secretary has submitted the Cabinet decision dated so-and-so along with the enclosures. The Cabinet note is of 91 pages, but possibly the longest Cabinet note in the history of this country after or even pre-independence. And something more interesting, I'll show to your lordships. Pages along with relevant copies of the judgments and legal opinion in reply to the show cause notice dated so-and-so issued by the Honorable Chief Minister. Further, so-and-so has submitted his reply to the show cause notice dated so-and-so along with legal opinion and relevant records, which runs through 60 plus odd pages. The State Cabinet, for the facts and reasons mentioned in the Cabinet decision, has strongly advised the Honorable Governor, not just an advice, it's a strong advice to the Governor to withdraw the notice dated so-and-so issued to the Honorable Chief Minister based on the petition and addendum dated so-and-so filed by one T.J. Abraham, and to proceed forthwith to reject the said application by denying prior approval. The Honorable Chief Minister in his reply has requested to peruse his reply as well as the advice rendered by the Cabinet with its resolution dated so-and-so and to withdraw the notice issued to him and to deny prior approval and sanction sought by the petitioner by rejecting his application. With the above details and along with records submitted, the file is placed before the Honorable for kind perusal and orders. My lord, these are the documents submitted by Mr. Abraham as well as by the government. Then, my lord, at the foot, is the note by the, note by the Honorable Governor, put up along with comparative statements of petitions, Chief Minister's reply, and the cabinet decision. Put it in 3 different compartments, which your lordship would find. Your lordship need not read it, just, my lord, for the flavor of it, my lord, page 1236. No, I'm sorry, my lord, it is 1224, my lord. There are 3 or 4, my lord, A3 type chart prepared. Just, my lord, have by way of an example, 1224. Well, there is a chart, my lord, of this size. It would be easier to find, my lord.
Yes, yes.
1224.
Yes.
There are 3 columns. Petition of Sri T.J. Abraham.
Yes.
Then specific rebuttal of allegations in the application for approval or sanction. And
Yes.
factual metrics.
Yes.
Lord, similarly, if your lordship goes through the other chart, and I'll come, my lord, show cabinet reply and CM's reply,
Yes.
which is, my lord, the second chart at page 1208. Then comparative statement of all the 3 petitions.
Yes.
This is where the governor comes to know that they are relating to the same transaction.
Yes.
So I need not follow even an empty formality of issuing notices. The allegations are same with respect to the same land, etc. Now kindly come back, my lord, with me to the my lord, noting section. Your lordships may kindly come to page 8 now of the file noting section.
Yes. Yes.
21, my lord, para number 21. The file notings are I seriatim numbered and paginated. As directed at para 20, comparative statement of petition received from so-and-so, and the Honorable Chief Minister reply and the cabinet decision are placed in the file for kind perusal of the Honorable Court. Now, please see 22 is very, very important, my lords. This is the Honorable Governor's noting. Peruse the file, discuss the issues. He discusses the issues with the officials, my lord, who are assisting him. Hence, resubmit the file along with notes, analysis points as dictated. My lord, he goes through these charts and dictates at page 1236 his own prima facie conclusions. My lord, page 1236, allegation, reply, and the 3rd column is what is dictated by the Honorable Governor. It is from page 1236 to 1225. So the page numbering is reversed, my lord, as your lordship, sir.
Yeah, that is the government files.
Government files. So, my lord, each and every allegation, the reply of the Honorable Chief Minister and cabinet, he considers and he dictates that this appears to be the prima facie situation. Then, my lord, para 9, page 9. This is, my lord, by the Special Secretary to the Governor. Pre-paras may kindly be perused. The petition received from, then 3 numbers, requesting grant of sanction for prosecution in respect of irregularities conducted and corrupt practice adopted by so-and-so.
Yes.
This is the language used in the complaint. He doesn't say that this is, we are dealing with sanction for prosecution. He is reproducing the language of the complainants.
Yes.
Then 26, as directed, the file, along with the above details, documents, and comparative statements, please note, dictated notes by the Honorable. That is Honorable Governor. That, my lord, appears to be the way in which, my lord, the Honorable Governor is referred to within the office.
Yes.
Is placed before the Honorable for further necessary orders. Then, my lord, page 11. Petitions received from Sri T.J. Abraham. My lord, this is the note, my lord, prepared by the Honorable Governor. It is signed, my lord, at page 25
Yes.
by the Honorable Governor.
Yes.
Petitions received from Sri so-and-so, so-and-so, and petition with additional documentation, petition from Sri so-and-so, 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 requesting grant of sanction for prosecution in respect of irregularities conducted and corrupt practices adopted by so-and-so, concerning allotment of alternative site by MUDA under various sections of PC Act and BNSS Act has been perused. He reproduces what the complainant say. He doesn't say I am dealing with sanction prosecution. In view of the allegations and on a prima facie perusal of the petitions for grant of sanction for prosecution and materials in support of the allegations, a show cause notice dated so-and-so along with the copy of the petition by Sri T.J. Abraham and material in support of the allegations was issued to Sri so-and-so. The reply to the show cause notice dated so-and-so along with annexures was received at Office of His Excellency the Governor of Karnataka on so-and-so. It appears from the material annexed to the reply, my lord. I need not read, my lord. It reproduces, my lord, the contents of various things, my lord.
Yes.
Please come to page 15.
Yes.
Or, my lord, at page 16.
That is 31.2.
31.2. The Chief Minister is the head of Council of Ministers. The Council of Ministers is normally required to act fairly and in a bona fide manner. However, the Council of Ministers is appointed on the recommendation of the Chief Minister. So please note here, this is the constitutional mandate under Article 164. 164 requires that the governor would appoint ministers on the recommendation of the Honorable Chief Minister. This is one of the factors which the governor considers whether to act on his own discretion or as per the aid and advice. It is but natural that stance of Council of Ministers is in support of the Chief Minister. Hence, in such extraordinary circumstances, it is hard to ascertain that the Council of Ministers have acted fairly and in a bona fide manner. The governor, under Article 163 of the Constitution, is required to act under the said aid and advice of Council of Ministers. However, an exception may arise when consideration is being done for grant of sanction for prosecution of the Chief Minister and the decision of Council of Ministers is affected by apparent bias. As regards the application of doctrine of aid and advice is concerned, this has been conclusively settled in state of Maharashtra versus so-and-so that sanction to prosecute the Chief Minister is the exclusive function of the governor to be exercised by him in his discretion, followed by the decision in case of Dr. J. Jayalalitha versus so-and-so, wherein it was further amplified that it is erroneous to say that the view of the Supreme Court was based on a concession made by counsel, and the perusal of the relevant part of the judgment shows that the court has expressed its opinion that such concession was rightly made. In the present matter, the allegations and the material in support of allegations would prima facie indicate that the said land was given to SC person by due course of law. The record of the said land was transferred from the father to children and again from children to father. This mystery was not considered by the state cabinet. When the notification, now he says why I am not relying upon state cabinet. First he says that even as per law, I am supposed to use my own discretion, not aid and advice. Now he goes further. State cabinet, when the notification for land acquisition issued and the denotification order was issued, Shri so-and-so was the member of Legislative Assembly from so-and-so constituency as well as a member of Mysore Urban Development Authority. And further, this land was purchased by a brother-in-law of Shri so-and-so, wherein the seller was from the constituency of so-and-so, and later on after getting the land converted into the residential purpose, gifted it to the wife of Shri so-and-so, who became the owner of the property, and the application for allocation of alternative sites came to be moved on the basis of relinquishment of agricultural land. On the basis of this application, MUDA passed the resolution pursuant to the amendment to allot alternate sites. It has been specifically averred that the rules was specifically amended, averred in the complaint. He is giving a prima facie consideration whether a cognizable offense is made out, which needs investigation. A rule was specifically amended from 40-60 to 50-50 to aid this transaction where so-and-so was the chief minister. Further, the petition seeking grant of sanction for prosecution and material provided clearly indicate that Sri so-and-so, son of Sri so-and-so, participated in MUDA meeting, which resulted in allotment of alternative site in very prime layout called Vijayanagar. These facts were placed before the Council of Ministers. The aforesaid brief facts, when correlated with the material in support of grant of sanction, clearly establish that there is apparent bias in the decision taken by the Council of Ministers in favor of Sri so-and-so. Due to this apparent bias, the present matter requires my independent application of mind to the petition seeking grant of sanction for prosecution and the material in support of the same. It is seen from the decision taken by the Council of Ministers that a committee under the chairmanship of Sri so-and-so was constituted to look into the present matter. However, the government, upon considering the facts of the present matter, as reported in the media and newspapers, appointed.
My lord, it is 292.
292. Yes, sir.
On the top, my lord, it
Yes.
is getting smudged, it's getting mixed
Yes,
up.
yes, yes.
Now kindly come to 28. Para 28. Page number is 292.
Yes.
The sentence starts, there is no provision.
There is no provision.
Yes, there is no provision either in the 88 Act or Code of Criminal Procedure which bar the citizen from filing a complaint for prosecution of public alleged to have committed offence. Therefore, the argument of the learned attorney general that the complainant cannot file a complaint for prosecuting respondent for merits rejection, then Antule, and then para 30. Kindly see para 30. While dealing with the issue relating to maintainability of private complaint, the Antule's portion is well recognized principle of criminal jurisprudence that anyone can set or put the criminal law into
Yes,
motion
that's-
except where so and so.
That's
And my lord, para 44.
Hmm.
Para 44.
Yes.
And para 44, and then kindly see 44, my lord, the middle of the line. By the third line, my lord, whether the facts placed before which in a given case may include the material collected by the complainant or the investigating agency.
Yes.
Kindly see that third line, my lord. Let me read it. We may have a grant of refusal sanction is not a quasi-judicial function, and person for whose the prosecution sanction is sought is not required to be heard by the competent authority before it takes a decision the matter. What is required to be seen by the competent authority is whether the facts placed before it, which in a given case may include the material collected by the complainant or the investigating agency, prima facie disclosing commission of an. So source can be any, person may be any. Then, my lord, your lordship may kindly make a note, para 68 and 75. Para 68,
Yes.
today corruption, etc. 75. Now kindly see 75. Just permit me to read these few lines.
Yes.
Therefore, in every case,
Yes.
and this is also one of the, my lord, concurring opinion, in every case when an application is made to an appropriate authority for grant of prosecution connection with an offence under the PC Act, so my lord, please see appropriate authority. So whichever authority, whatever is needed, I as a citizen have applied.
Hmm.
So what is to be done now? For grant of prosecution in connection with the offence, it is the bounden duty of such authority to apply its mind urgently in the situation and decide the issue without being influenced by any extraneous consideration. In doing so, the authority must take a conscious effort to ensure the rule of law and cause of justice is advanced. In considering the question of granting or refusing such sanction, the authority is answerable to law and law alone. Therefore, the requirement to take the decision with a reasonable dispatch is the essence. In such a situation, delay in granting censure proposal thwarts a very valid social purpose, namely the purpose of speedy trial with the requirement of bringing the culprit to book. Therefore, in this case, the right of the sanctioning authority while either sanctioning or refusing to grant is coupled with a duty. The sanctioning authority must bear in mind, and up to 77 that, my lord, they are saying that there should not be any delay in that regard. Therefore, my lord, if your lordship may kindly see at the cost of repetition, what I am submitting and making my humble submission, my lord, for this respondent is that sufficient objective material with their admission now through the form of their notes and document has come on record. And therefore, my lord, an investigation is needed. Whatever is required to me, either to file a complaint or to apply to the governor under 17A, whatever is applicable, I have done so, and my lord, in this jurisdiction under 226, notwithstanding who has invoked it. If your lordships are satisfied, my lord, that the case is made out, that the investigation should not be impeded, my lord, your lordship would consider that, my lord, and my lord decide. the matter. That's my respectful submission, my lord, only with the liberty that I'll hand over my note with
Yes.
whatever I've read in, my lord, by today evening or by Monday.
Yes.
And Mr.
So-
Raghavan, my lord, has requested me to, my lord, we will supplement it on Monday something. my lord. Grateful, my lord.
I have about half an hour.
Continue, 2:30. ಆಯ್ತು, 2:30, 2:30. You have concluded, Maninder Singh, sir?
Concluded.
Yes.
2:30.
Sir is also concluded? Yes. We'll continue at 2:30.
I may leave a little early today,
Yes,
but
sir.
I'll be there, whether it's virtual or physical, when Mr. Raghavan is
problem, sir.
arguing, then I'll work out the dates with the lordship.
So you want to reply to the submissions already
I
made,
need
you
to
can.
put all this together now. There's
Yes.
a massive 61 page plus all these other things. I'll want to in fact take
That's
some
better.
time to put things together into one single
Yes, sir.
doc, Palas. So
Yes.
in any case, Mr. Raghavan is arguing, so you can.
Yes, sir, yes.
take. So I was just.
Anyway,
saying,
my
I may
lord,
be
I just
excused- I
clarification.
may be excused for the last half an hour or one.
No problem.
Considering, my lord, the scope of the present petition, whatever my learned friend Mr. Singh argued, is obviously only for the purpose of showing that it's not just a haphazard way of prosecuting someone. There is a material. So it's the scope of the petition would not include
While,
defense, etc. my lord.
while your lordship is rising, this is not the right time, but I'm very, very touched by this slight, very mild caveat. I didn't interrupt Mr. Singh once, but it's going to be my argument that in my sanction, my learned friend has argued anything but sanction. He has argued merits.
No,
Every
that's what-
case he has cited
The
is a
reply-
case. He goes to the extent of saying in my sanction petition, your lordships can become a 226 court to grant him sanction. That's his argument.
No.
Not
Just
one
to
single
prima facie
sanction
show
case
that
is
there is a
cited.
material.
Argument is that there is abundant material.
No, he
Not
says
that you
anybody
can give
come,
your
therefore
defense
sanction
here
can be
and
granted.
get a acquittal.
Anyway, well, we'll
You
deal with
can't
that.
argue on defense.
Because locus neutral, therefore anybody can come. Governor must grant sanction. Because anti-corruption, public trust doctrine, we are arguing a sanction under 17A or 19 or whatever it
Right.
is. Not a word about it. But anyway, well, that's why I need some time to analyze these cases, tell you what these cases are about. They are chalk and cheese, brothers. We're talking of North Pole and South Pole of the subject. As I'm concerned.
Yes. Yeah. We'll continue at 2:30.
Please.
Yes, thank you, sir.
Completed in 98, award made, compensation deposited, etc. I will come to one more document. Development completed, plots sold by written document, my lord, the learned AG was a little uncharitable in his note saying it's only a paperwork. My respectful submission is the entire thing to the contrary is paperwork. So 2001 to 2004 plots, sale deeds are in existence. Sold. Now, my lord,
The very same lands.
very same land, admittedly, it is no more remain, and I am having one more grievance, my lord. In the cabinet note, a writ petition order is cited. The writ petition order, particulars of the writ are not given. Order is not shown. And the foundation is made for giving these 14 sites to the petitioner's wife on the ground that High Court has passed an order of a same nature in a similar case. So I had the curiosity, where is the judgment? Let us see this judgment. In, my lord, 5 notes of the same kind. Fortunately, my lord, somebody gave the number. I've got that order. Kindly give the copy, sir. Udhar bhi do. This is the order, my lord. I'll show to your lordship as a part of the cabinet note, part of the opinion. In, my lord, at some place, number is given in the opinion, number disappears. The read number disappears. The name disappears. Similarity remains. Now, what is this case? Somebody,
This is all the order?
this all is the order. I'll show to your lordships. Just give me one moment, my lord. I want to say something. This is available, downloaded from the High Court site, my lord. I'll show that, my lord. In any case, they will have something more.